Today, we're going to tackle a really difficult but also incredibly important topic. How does the law actually respond when a life is lost because of someone else's negligence or fault? It's a profound question, and here in Scotland, the answer is found within a single powerful piece of legislation.
And this really is the central question, isn't it? I mean, when a family is facing the absolute unthinkable, whether it's from an incident at work, a car accident, or some kind of medical negligence, what happens next? What legal rights do they actually have?
Well, in Scotland, the answer is the Damages Act of 2011. This single piece of legislation is basically the entire playbook for these tragic cases. It lays out exactly who can make a claim, what they can claim for, and how the legal system tries to provide some form of recognition and support for what is, let's be honest, a truly immeasurable loss.
Okay, so let's start with the most basic question. Who is this law even designed to protect? The Act uses a very specific term, relative, to define who gets to bring a claim. So right away, you can see the law's definition of a relative is really broad, and that is absolutely on purpose. It goes way beyond just the immediate family to include partners, siblings, grandparents, even aunts and uncles. But what's really forward-thinking is that last one. It also includes anyone who was accepted as a child, even if there was no formal biological or legal link. And this quote, this really gets to the heart of it, doesn't it? The lawmakers behind this act recognize that real families are complex, and the emotional and financial fallout from a death doesn't stick to neat little lines on a family tree. So the act was designed to reflect that messy human reality.
Now, what the Act does here is really clever. It creates this crucial distinction between two totally separate types of claims that actually run alongside each other. It's a way of looking at the loss from two different angles, from the perspective of the person who died and from the perspective of the family they left behind. This breakdown really shows the two separate injustices the law is trying to address. On one hand, you have the executor's claim. Think of this as the claim for the person who passed away. It belongs to their estate, and it covers the suffering and the financial loss they went through before they died. And then, completely separate, you have the relative's claim. And this one is all about the profound loss the family experiences after the death.
All right, so let's dig into that relative's claim a bit more. You can see it's built on two fundamental pillars, two main ideas. The law recognizes that a person's value to their family is both financial and deeply emotional.
So the law separates the financial hole left behind from the emotional one. Loss of support, that's the tangible stuff. We're talking about lost income, sure, but also the value of services that person provided, like childcare or DIY around the house. And then you have loss of society, and that's for the intangible, but no less real human loss, the grief, the sorrow, and just the absence of that person's guidance, their care, and their love.
Now, it's so important to get this. Loss of society isn't just some token payment for being sad. It's way more than that. It is the law's genuine attempt to provide real legal recognition for the immense emotional cost of losing a parent, a partner, or a child. And this focus on the full human dimension is a core part of what makes the Scottish system so distinct.
Okay, now for some of the nuts and bolts. We're talking about important rules to know, time limits, and protections. And for any family trying to navigate this process, understanding these practical details is absolutely critical.
And this first one is huge. You have 3 years to bring a claim. But, and this is the vital part, that clock starts ticking from the date of death, not the date of the accident. This is so crucial because, tragically, a person might survive for months or even years after the event that ultimately caused their death. And here's another really important protection built right into the Act. It's called the disregard of benefits principle. The thinking behind it is pretty straightforward. The person who did wrong shouldn't get a lucky break just because the person who passed away was responsible. It means any life insurance or pension payouts the family gets are completely ignored when calculating compensation. The family is entitled to both. So, to really appreciate why the 2011 Act is so significant, it helps to see how it stacks up against the law just south of the border, in England. And believe me, the approaches are meaningfully different. This table lays it all out pretty clearly. In England, there's a fixed, standardized bereavement award that's only available to a very small group of people. In Scotland, though, we have that loss of society award, which is assessed individually for a much wider range of relatives. This means the Scottish approach is just far more nuanced. It looks at the specific relationship each person had with the deceased, and it really aims to reflect the full human dimension of their loss, something critics say the English system often fails to do.
You know, at the end of the day, the law isn't trying to put a price tag on a life. It can't. And as this quote says, it doesn't even pretend to. Instead, the goal of the Damages Act is really twofold. First, to make sure a grieving family doesn't also have to face a financial crisis. And second, to provide true legal recognition for the profound emotional cost of their loss.
So it all comes down to this question, doesn't it? Does a legal system that actually tries to measure emotional loss do a better job of serving a grieving family? Well, the Damages Scotland Act 2011 provides one very comprehensive answer. By valuing both the financial and the human dimensions of loss, it really leaves us to think about the profound and incredibly complex role the law plays when faced with our deepest human tragedies.